Number 196, People versus Holley.
Yes, Your Honor. Andrew Fine for the defendant, Mr. Holley. This is another identification case in which there's an issue of fundamental fairness presented. And that is, if you have a Wade hearing, should the judge have the opportunity to evaluate the procedure that was conducted by looking at it? Prosecution says no. Prosecution says there is no duty on the part of the police to save and copy and keep a copy of a computerized photo array that's generated by a computer.
Yeah, but were there other IDs in this case aside from that one witness who looked at the, what's it called, the photo manager program?
Yes, there were two witnesses.
So what about them? Why isn't they weren't influenced by the?
Well, first of all, Ms. Han, Yumi Han, who did not see the photo array, did see the lineup, which we contend independently is suggestive and taints her in court identification.
What is independent? What was wrong with the lineup?
But what was wrong with the lineup was it was suggestive as a matter of law. That's our argument in this case. And
Counsel, you want rebuttal time?
Yes, I'd like 2 minutes, Your Honor.
Keep going. Go ahead.
Yes.
So what's wrong with the lineup? Say it again.
What's wrong with the lineup? I mean, that's a separate part of our argument. But
yes, but again, if there's independent of the photo manager, if you have good IDs that are not influenced, even if you're right, by any suggestiveness, why do you have a case?
Take a look at the lineup, Your Honor. It's on pages A7 and A8.
Yeah, we've looked at the lineup. What's wrong with it?
What's wrong with the lineup is that the defendant was the only person in the lineup who was basically within the range that the photo manager selected initially, which was the basis of the composite description given by the eyewitnesses. They were collecting people black men between 30 and 40 years old, between 6 foot and 6'4". Our client was the only one who fit within those criteria. The only person who was not either heavy or much older than the defendant was the person standing next to him, and that person was 22 years old.
You're saying as a matter of law the lineup was no good?
There is no support
based on the photos of the lineup?
There is no support in the record for the conclusion of the lower courts that the lineup was not impermissibly suggestive. The defendant actually does stand out like a sore thumb. If you know what the criteria were, you know what the identification criteria were that were given to the police by the identified witnesses.
What's your precedent that tells us that's a matter of law, because you argue that he's skinnier than the others?
Not just skinnier, but the only person.
Why is it a mixed question, the lineup?
It is a mixed question ordinarily, but when there's no support in the record for the lower court's determination, this court has the power to evaluate it as a matter of law.
What about McBride, the case?
There are cases in which the court has held that a lineup is not reviewable. This is not such a case, because we have a situation here where the lineup is suggestive as a matter of law. There is no way to evaluate this lineup if you know what the features were that were given to the police by the identifying witnesses, and you look at this lineup, you'll see that the defendant is 32 years old, he's skinny. The only other skinny person in the lineup is number 4. Number 4 is 10 years younger than the defendant.
Yeah, but they're seated. So you've got them seated, the clothing they're wearing. We've looked at the photographs. Our problem, of course, is we have black and white photos. They aren't quite.
It also does not.
But it doesn't solve your legal problem. I want to take a step back. I know you want to talk about the lineup, but I want to talk about the photo management system. I think the appellate divisions all agree that failure to preserve the array creates a rebuttable presumption.
Yes.
All right. So that being the case, isn't the presumption? So I'm assuming. Let's say we did that. This is a suggestive. It's suggestive, and that clearly they can preserve the computer records, and that doesn't seem to be a difficult problem. Why isn't the detective's testimony enough to really rebut the presumption?
Because the detective did not input into the computer the appropriate criteria to evaluate the photo array, number one. First of all, we contend as a threshold that the entire array should have been duplicated regardless, because there is no legitimate reason.
That's okay, but I just want you to just answer my question.
Assuming that there is no absolute duty to preserve the array, assuming that there's an inference of suggestiveness that the people are trying to overcome, the reason that they didn't overcome it here, in addition to the fact that there were only 12 photographs that were actually put out before the witness made the identification, only 12, not 70, not 80.
Yeah, but she looked at 132, I thought.
She looked at there's a dispute as to how many she looked at. But once you look at the defendant's photograph and identify that person as the perpetrator, it sticks in your mind that there is scientific research that has demonstrated something called a commitment effect.
So you're saying that in any situation where the witness happens to pick out someone in the first few photographs, that's going to be presumptively suggestive?
Yes, absolutely, Your Honor. There has to be.
How many does it have to be? Does it have to be 20? Does it have to be 50? Does it have to be 150? When does it not become presumptively suggestive?
Well, there are two answers to that. My main answer is if you have the technological ability to press copy, file, and print, there's no justification for not allowing the judge.
You're saying if they had pressed copy, file, and print, and she had made the identification in the first 12 pictures, that could be okay, right?
Sure. If the judge had an opportunity to look at the two pictures and determine that there was no suggestion, that would be fine.
So my point is, so are you arguing that if you don't press copy, file, and print, that's dispositive?
That's one of our arguments.
It's an absolute requirement.
But our backup argument here is that when you have a situation in which you have the police officer who determines which photographs are going to be in the array does not input one of the composite portions, important composite portions of the description given by the identifying witnesses, in this case, namely, that the person was skinny, and leaves that out.
How do you decide that? I think back in the old days when they had the big picture books, and you'd flip through. You wouldn't want that. I mean, that's just showing everybody. So put yourself in the position of the police in not your case, but in the next case. What do? They've got this system that's supposed to be pretty sharp. It's got 3,000 pictures in it or something. You wouldn't want them to show off 3,000 pictures because that might be influential in one way or another. You wouldn't want them to show 6 because that would be, trying to influence the. What are the police supposed to do when they're trying to?
We're not criticizing the manner in which the police showed the array to the witness. We're contesting the manner in which the police officer generated the array in the first place.
Right. So how should he generate an array if he's got 3,000 possible pictures?
Well, he shouldn't have had 3,000 possible pictures because if he'd input thin frame or thin build.
No, you're saying that it's okay to use the computer then. You're not.
That's fine. But when you have a composite description, there is no justification for not inputting into the computer every important element of that composite description, which in this case includes thinness. The officer admitted he could have done.
Let me follow up on that. My definition of thin, you're thin. Aren't you happy about that?
I plead.
You would dispute that.
Not guilty to that allegation.
So how do you decide stuff like that? How do you decide tall? How do you decide?
Well, the computer has criteria for evaluating body type, and the officer admitted that. He could have input basically a thin build into the computer,
Could you put in
and
a
it
fat
would have
build?
Eliminated fat people from the computer.
Could you put in? But that's the point. I mean, your thin and my thin aren't the same.
Yeah. I mean, there's no such thing as a perfect array,
right.
But this would have made the array unquestionably much fairer than it would have been necessarily otherwise. In these 12 photographs that the witness saw, there may have been 4 or 5 people who were obese.
Right, but your point is that that particular characteristic matters because it is actually displayed in the array. It's obvious from the array, because if it's a characteristic that you can't tell from the array, it wouldn't matter.
Well,
that are shown.
Well, the array that would have contained pictures only of skinny people was not preserved in this case. We're not saying that the array would have to include fat people in order to be suggestive. We're saying that the police officer has an obligation to input into the computer all of the criteria that were given by the witnesses.
Counsel, but let me come back to the point before. If the lineup was okay, it doesn't matter, right?
Okay.
They both have to, in order for you to win, both the array has to be bad and the lineup's bad because there were people who didn't see the master program, right?
Well, there are 3 witnesses in this case.
Yes.
The witness who saw the array.
2 others who didn't see the master program.
If the witness who saw the array is eliminated, we're down to 2 witnesses.
Right. So if the lineup is good, you lose, right?
No, the lineup is good, we don't lose.
Why not?
Because we have only 2 witnesses left, and one of those 2 witnesses, Ju-Eun Lee, made no prior pretrial identification at all. The issue which was being discussed in the previous argument. There were months that went by.
So you can't just have it at trial.
You can't just basically say she's fine and her identification is reliable.
What about the third witness?
The third witness, Uni Han, made an in-court identification, but was exposed to the suggestive lineup. You're dealing with.
But I asked you if the lineup was good, can you win?
Yes, because the errors were not harmless. In this case, there was no evidence against the defendant other than identification testimony. This crime occurred in Manhattan. The officer had to go to Brooklyn and to Bedford-Stuyvesant to a homeless shelter to arrest the defendant. When he arrested him, he apparently was not wearing any of the clothing that was described by the witnesses as had been worn by the perpetrator.
He probably hurt himself, though, when, after he did the purse snatching, that he came back and tried to assault the defendant. I mean, at least they had 2 shots at getting its ID right.
I'm not sure what you're asking, Your Honor.
When they went to report the possible purse snatching?
Yes.
Didn't he come back?
The perpetrator came back, yes. If it was the defendant, the perpetrator came back.
Okay, counsel. You'll have your rebuttal. Let's hear from your adversary.
May it please the Court, Joshua Haber for the people.
Counsel, don't you have an obligation to produce these pictures, the master program, copy it, and give it up? Why is that so difficult to do?
First of all, in terms of whether we had a legal obligation here whether the police had a legal obligation to save and produce these photos, there is not a single court that
but doesn't it make common sense that you have that obligation?
No, Your Honor, and that's because
No, you don't. You have it at your disposal, and you're not giving it in to. Isn't the basic issue of fairness?
No, Your Honor, because when we're talking about the specific procedure used here, a canvassing array, the inherent nature of that array is inherently non-suggestive for the important
Well, you say that,
fact.
but that's our point, I think, is the people want to say, well, it's totally non-suggestive. We are so good at this that, believe me, we're right, and therefore there's no reason for us to save what we showed to the witness.
You've created a situation where your presumptions can't be tested. If you say that the system itself is inherently ensures against this, then you say that this can't be tested in the court of law, and that can't be what we're here for. We're here to make sure that everybody gets to test the alleged facts.
The issue is not the system, in other words, the photo manager system. The issue is the point at which the identification is occurring in terms of the investigation. The concept inherent in suggestiveness, decades worth of case law teaches us, starts with the premise that the police have a suspect in mind. You go back to Wade, you go to this Court's rulings in Chip and so forth. The police always have a suspect in mind. And therefore, when they create an array or a lineup around that particular suspect, of course, a court wants to look at the fillers that were surrounding that suspect.
Because of computer sophistication now, you can have a profile in mind even though you may not have a suspect in mind. And that may be what we're dealing with here. And because of the way data is gathered now, you can do that. So shouldn't that be available to the other side?
If there were any evidence of this case that the police had a profile of somebody in mind, I would agree with you, Your Honor.
They had the profile of a guy of a tall, skinny, African-American male and with a particular age range and a particular body weight. So they did have a profile in mind, and that's why when you look at the lineup, if it's not suggestive, then they roughly met that. The same thing would apply to a photo array. Why not turn that over to both sides?
Well, the biggest problem that we have in this case, really, is a lack of a record. Okay. The defendant.
So let's talk about a rule then for future records. Should we require that they be turned over? That even if should we say that if you don't, like the other appellate division says, that you've created a rebuttable presumption, and that you can respond. I asked the other side about whether or not the detective's testimony was sufficient to do it, but nonetheless, shouldn't you be able to do that?
No, Your Honor. Again, there should not be a rebuttable presumption when there is a canvassing array like the one that occurred here. First, for
if the record isn't preserved, I'm talking about.
I'm sorry?
If it's only a rebuttable presumption if the record isn't preserved.
Yes. Again, I would strongly encourage Your Honors not to require a rebuttable presumption if a canvassing array of hundreds or thousands of photos are not preserved.
Can I ask you a question? If it was to be saved and printed, save, file, print, whatever, would it come out in the same order as it was shown to the witness?
Again, getting back to what I was saying in response to Judge Fahey's question, there's no record here. There's just no record in this case. The defendant
So we
asked,
don't know, you're saying we don't know
we don't
the
know.
answer.
We don't know. The
Oh, no, but
defendant
let me follow up on
Yes.
this question. Other than we don't know here, the point is the capacity there to print it out that way?
we don't know in this case.
No.
Yes.
I'm not asking about this case. I'm
Yes.
asking as a general course, if you're using this kind of system. Are you saying you are not able to print it out in the order in which it was shown? There's no way to show pages or numbers for each of them?
My understanding is that today, in 2015, using a photo manager type program, that the police still do not print out pages of 500 pages of color photographs.
That's begging the question. Let's assume.
But they do. Sorry.
Let's assume for a minute that they showed her 15. Can't you preserve the 15 and say, these are the 15 we showed her, and then she picked out number 7, and that's the defendant, and here we go? Conceivably?
And this is the first page of the 15, and this is the second page of the 15. This
You're
is
saying-
the first photo of the total in the 15 pages.
May I just ask for a clarification question? Are you asking whether the witness only sees 15 photos or sees 15 and then sees another 60, like happened in this case, or another 80 that happened in this case? The point is that when you have a canvassing array where a witness is looking at 100, 200 photos, of course, every single photo that witness looked to
But what you're saying
is relevant.
you're saying to the court, we can overwhelm you. We can tell you that there are these thousands of pictures, and therefore, Judge, you can't ask us whether we were being fair or not. And I know you don't want to make that argument. What I'm asking is there must be some process. Let's assume this was a gun, okay? And the issue was a gun. And you didn't keep any of the ballistics information. You say, it's all done on computers now. But we can tell you this is the gun, this was the ammunition, this is the number of bullets that were fired, and the bullets match the gun, and the gun fits. And so where's the information for that? Well, we don't have it. Well, that's a problem. Well, why? We have a computer. It does a great job. It said, and when I thought about that, I thought, well, now what you're relying on is a hearsay statement from an officer who's saying, well, whoever did the tests, whoever ran the computer, did it right, and therefore this is the gun. And here we're saying, here's a police officer, ran the thing, she was sitting there, he's the one testifying to the accuracy of the photo array, and we don't have the photo array.
But in this case, it wasn't that the detective was testifying to the accuracy or inaccuracy of a particular identification. It was really similar to all of the mugshot book cases that predate this case, to all of the street canvassing cases where the police have a witness in the back of their patrol car, drive around a neighborhood, and ask that witness to see if they see anybody on the sidewalk who they identify. That's the kind of case that we're dealing with here. It's not
No. It is not like driving around the streets. Right, because first of all, the photo array is suggesting that that person somehow may have a criminal history, whether for whatever reason, as opposed to going on the street and just seeing people on the street. Plus, as you've already said, despite the fact that this pool may be limited to a particular category of perhaps some characteristics that fit a great deal of people, right? Thin African-American male of a certain age group and a certain height. Fits a lot of people potentially. Nevertheless, you have narrowed the field. So it's not like going around on the street.
And because the field is narrowed, I would actually argue that a photo manager procedure is more protective of defendants' rights because you're not looking at people on the sidewalk where maybe you have one tall African-American person walking down the street next to a bunch of white people. The fact that the photo manager system allows for a canvassing type
but there's no way
identification.
to hold you accountable. I think that's the question that we're saying. It can't just be because you say it, that this is the best system, it's totally non-suggestive, it's great. Maybe it is, but there's no way to check on what you're saying. It's a very one-sided approach that says, we're the prosecutor, we're the police, we know what we're doing, don't bother us.
I have to say, too, I think when you come into court, you assume a lack of computer sophistication on most of the judges' parts, but and that's pretty much true, generally for all of us, but I don't know. I can go back and check every single page of my computer on what I looked at, and it seems to me that you ought to be able to do that at the end of any photo array. you print out the list, you keep it, you got it. And so, so not to do that then creates a presumption that you've destroyed the array or the sequence that they came in, and therefore you can rebut that presumption. But nonetheless, it challenges it.
But for the same reason that a court has never applied a rebuttable presumption in the case of a mug book, okay, the same concept applies here. You're talking about tens of thousands.
Here's the difference. So the officer gets up and says, I collected 50 pictures. Your Honor, counsel, they looked like this. I collected them. I don't need to show them to you. Believe me, that's what they look like. Is that good enough?
Yes, because in People versus Raming, decided by this court, that's exactly what happened. The police officer in that case showed a box of 60 to 70 photos to a witness. The court specifically observed that in that case, the people did not produce those photos at the hearing. Nonetheless, overall, based on the totality of the circumstance, this court held that that ID procedure was not inherently suggestive and did not apply any presumption.
We also had
here.
a case, it was a civil case involving someone that got beat up in a prison, and they video everything. They've got hundreds, if not thousands, of videos. This one got destroyed. We thought that there should be a presumption that it was destroyed because it was not favorable to I think in that case, the county or the state. Were we wrong? I mean, should we have said, well, there's thousands of them. Why, if they say, what happened, why are we to say, well, you got to have a tape, that would have shown it and you didn't, and therefore there's a presumption against you?
Again, I just want to step back and focus on the point at which the investigation is taking place here, and the really minimal threshold of potential suggestiveness we're talking about compared to the burden that we're also talking about in terms of making the state turn over and save tens of thousands of who knows how many gigabytes, pages that the defendant could have made a record about and failed to.
This great burden in the age of modern technology, are you serious that this is such a big deal?
100%, Your Honor. We're talking about tens.
Where does it say that it's such a big deal to, as your adversary says, push the button and you have it? How do we know what you're saying is accurate?
We don't, and the reason for that is because
why are we accepting what you're saying?
We don't have that information because it was defendant's burden here to create such a record if he wants to rely on that kind of argument. And we don't have that record.
I don't know. You're saying that they've got the burden to show somehow that because you showed them pictures that somehow they were not suggestive, or they were suggestive?
Taking it one step further, she identified 3 photos. I think Sylvia, her name is, among 132. It's just hard for me to see how there's any burden being created by the people to preserve that. And how can they do that since you're the one who has all the information? You got to preserve it. No one else can preserve it.
No, the argument that they have to make is that there was no law saying that we had a presumption to preserve in this case. To the extent that
I got to say, I'm reading the appellate division cases a little differently than you on that, but that's all right.
And we're talking about maybe we should create, maybe we should make the rule of you because it's not fair that you don't produce it. That's the whole basis of the argument that we've been going around in circles for the last 5 minutes.
Your Honor, Judge Fahey, you asked this question in the prior case. Is this the wrong case? To the extent this Court is thinking about making that kind of sweeping rule that would affect literally hundreds of thousands of investigations across the state, we need a record to determine that.
I don't know if it's 100,000, and I don't care about Megs when you're talking about liberty interests. This guy did 2 years, and let me finish. And that's one thing. But if they're doing 25 to life, are we going to say, well, wait a minute, you're asking us to download 25 megs of stuff? He can do the time, and then we're okay. Next case.
A burden obviously always has to be considered relative to the protection that we're talking about here. But because of the inherent nature of this particular procedure, where there is no suspect in mind beforehand, the level of suggestiveness that we're afraid of here, where there is no suspect, just doesn't rise to the level of, at this point, creating that burden without a record.
Counsel, we get you. Let's hear from your adversary.
Thank you, Your Honor.
Judge Fahey was mentioning the appellate division cases. My adversary is saying that there are no appellate division cases recognizing a presumption in this situation. That simply is incorrect. 2 cases from the Second Department, Dobbins and Robinson, Dobbins, my adversary, attempts to distinguish on its facts, and Robinson, he's arguing, is wrongly decided. But these are two cases which necessarily recognize the ease with which these kinds of files can be retained.
What we're arguing about, you agree there's no Court of Appeals precedent on this issue?
No, there is no Court of Appeals precedent.
But you would advocate that we do make that kind of a rule, right?
Yes, I would advocate that we do, because we have a situation here where we have modern technology, and you shouldn't go back to Rahming and look what the court was thinking about in 1970. You should look at modern technology to determine the answer to this question. One very easy way to make it clear exactly what the danger of misidentification is in this situation and how preserving the array might help, isn't it miraculous from the people's perspective that they compiled over 3,000 photographs of all the people meeting the identification criteria in the entire borough of Manhattan over a period of 4 years, and this witness picked out our client on the second series of 6 photographs.
It's possible, isn't it, counsel?
Yes, it's possible, but the reason, what are the dangers here? The dangers are, first of all, we had somebody who was obviously prepared to identify someone.
All right, so you want protection as to the suggestiveness that we can check on?
Yes, but I just continuing. She said, basically, the officer testified at the hearing that he asked the witness, can you ID the person, before he showed her the photographs. Right. She said she would. So she was clearly ready to make an identification.
Well, you can get into that fencing all the time. That's when you get into mixed questions of law and fact.
But the other problem, well, we can't have a mixed question unless the lower courts had an opportunity to evaluate the procedure itself, and they didn't in this case. But in this case, you have a situation in which you have obviously the potential that not only was the person ready to make an identification, she may have been suggested to make an identification. Maybe the defendant who was only the 12th person she saw, maybe he was the only skinny person in the lineup.
Okay, counsel, we're going to take a look at it. Thank you both.